Welcome to Rising Leaders of New York with your host, David Zwerin of Hill & Moin, LLP. They present to you conversations with today's and future leaders of New York City discussing the challenges and issues relevant to New Yorkers. You can find this show at www.hillmoin.com and on YouTube, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, and more. Now here are the hosts of Rising Leaders of New York.
Hello, everybody. Thank you for joining me, David Zwerin, here on this episode of Rising Leaders of New York. This is my opportunity where every episode I get to speak with people who are on the cutting edge of important issues, often legal, that New Yorkers need to know about. And today I have a very exciting guest, joined by my old friend, Christopher Baluzy. He is a partner at the law firm of Cary Kane. They practice in the areas of labor, employment benefit unions on behalf of labor unions. He arbitrates disputes, he negotiates collective bargaining agreement, and is a litigator in the state and federal courts of New York. Chris is a tremendously knowledgeable person in dealing with fighting for the rights of employees and members of unions, and is an extremely knowledgeable attorney, and I look forward to having a great conversation with him today. So, Christopher Baluzy, thank you so much for joining me today.
Thanks so much, Dave. Very happy to be here. Thank you so much for those kind words.
No problem. So, Chris, you and I guess candidly, you and I have known each other for a little while, but
right.
tell the people a little bit about yourself. How did you end up being a lawyer? How did you end up getting into this particular area of law?
Yeah, so my journey, first of all, to, I guess, law school, start there, started in college, kind of a cliche. I thought, okay, I really wanted to be a physician, a doctor, but I hated the lab portion of the curriculum for that. So I switched to wanting to do a different profession that was law. Like I said, it's cliche, doctor or lawyer. And so I studied in college, liberal arts, and then worked at a big law firm as a paralegal in litigation. And those hours were very long, even as a paralegal, because we were there as long as the attorneys were in the building, basically. And I said to myself, if I'm going to be, working this much and like in an office like this for so long, I want to make sure I do something that I really enjoy doing. So it's not so painful. And at that time, I thought it was going to be civil rights, anti-discrimination law. And I went to CUNY Law School. At that time, it was in Flushing. Enrolled there, studied discrimination, Title VII, anti-discrimination, I should say, civil rights, Section 1983 cases. Really enjoyed it. And when I graduated, I wanted to stay on the side of course, helping people. That was the main motivation. And I started working for a union side law firm called O'Dwyer and Bernstein on a project, on a litigation that they were working on. They were representing an airline union. But I knew that litigation may end and they wouldn't need me. So it did eventually end. And I then went to work for another union side law firm for a couple of years, and practiced in the, representing unions, but also employee benefit funds for collections of monies that were owed to those funds, which wasn't very fun. The union stuff, though, was much more interesting. And then I came here to Cary Kane, and I've been here since January of 2015. So gosh, 8 years.
Yeah.
And yeah, go ahead.
So, Chris, you mentioned you've been doing union side work for a little while. For those people who might not have a lot of experience dealing with union litigation or negotiations, or maybe even don't so much have a lot of familiar with what a union is.
Right.
Give us a little idea, like what exactly is a union? What does it look like? How is it formed? And
Sure.
why do they need lawyers?
Sure, exactly. Thank you. So, what is a union? A union represents workers with respect to the wages, hours, working conditions of the employees of an employer. That is at its core what a union does. A union doesn't need to be already pre-existing to represent workers. The workers can form their own union, and the law defines that not so strictly, so that a group of workers can do that in the under the National Labor Relations Act. So it's a very powerful tool to get better wages, benefits, working conditions. So, like I said, that's what the union does. It represents the employees. The union negotiates contracts on behalf of the employees, of course, with the input of the workers. It's not just the union doing it on its own. It processes grievances, resolves disputes, ensures that there's sound labor relations at the plant or at the facility, the store, whatever it is. And sometimes it'll have to arbitrate disputes, come to a final and binding determination. But that's arbitration. It's not court litigation. But still, it's kind of like that. It's a formal process. And the union also can provide benefits to the workers through benefit funds that it has input on, health insurance, pension, sometimes legal funds where the union will help pay for legal services for workers, like for real estate or wills, that sort of thing. So the union, the core issue, the essence of its being is to help the workers, and that's its goal. And it's a very noble purpose.
And what types of services does your firm offer? You mentioned like a lot of things union needs. What exactly does your firm do, and what do you specialize in?
Right. So what we do is we represent unions as the institution. And so let's start there. So we represent the union in contract negotiations to advise on, what they should propose, what language, how language should read, because after all, it is a contract that's going to be read by lawyers. So we want to make sure the language looks right. We help with, strategizing about certain things, whether it's union elections, union grievances. We help the union process election petitions with the NLRB. So if they
what's the NLRB, by the way?
Okay,
the name I'm familiar with, but many people probably don't know what that is.
That's fine. Yes, the NLRB is a federal government agency. It stands for National Labor Relations Board, and they have jurisdiction over over unions and employers. With respect to all forms of concerted activity, strikes, elections, or elections to get rid of unions. It runs the gamut. And so we represent unions with that agency, and also for unfair labor practices. So if an employer violates the National Labor Relations Act, we file that unfair labor practice charge. And we also sometimes defend a union in response to an unfair labor practice charge filed by a worker, usually claiming that the union didn't fairly represent that worker. So that's somewhat of a big portion of what we do. And we also represent the affiliated benefit funds. So we represent, we're counsel to the trustees on those funds to make sure that the funds are, doing what it should be doing, in administering benefits, giving out benefits, paying benefits, collecting monies that are due to the fund, and that's another part. And we also sometimes represent individuals, so not just unions. We represent individuals for wage and hour cases or severance agreement negotiations. And let's see, sometimes discrimination cases. So that's another part of what we do. But a vast majority is representing unions and their funds. And let me just say one more thing, Dave. I'm sorry.
No,
we only represent unions. We don't represent management. We are entirely worker focused and union focused.
Right. So that was kind of getting to my original question when you talk about being a union sided lawyer. On the other side, that's management or the employer sided lawyers, right? And I assume that's who you usually are, if not adversarial with, in trying to ensure
Yes.
your side's rights are fairly represented in any disagreement or litigation or negotiation with management.
That's right. And what makes what we do somewhat unique, compared to a real, I guess, litigation attorney like you are, is this our representation is in the context of a relationship between the clients, between the union and the employer. And so what that means is we are going to see each other again. I, as the union side attorney, I'm going to see that management side attorney again. And it doesn't make sense. Sometimes you got to, but it usually doesn't make sense to try and kill each other, on a specific issue, because, like I said, I'm going to see this guy or this woman, in the other another week from now on a different matter. And it's a small world. So it's not the sort of situation where, like I said, you're trying to kill each other, where like on a slip and fall case or a tort case, you're trying to, kill each other and get the best for your client, of course, but you might not see, you're not going to see that attorney, ever again. And neither will your clients. That's the other thing. Our clients are the respective management of the employer and the union representatives at the union. And so they're constantly talking to each other on various issues, whatever it is. And it's going to be about the terms and conditions of employment of the employees and administering a contract. So they're always, in constant contact. It really requires a deft human touch, I think, to be a union side attorney and an employer side too.
No, you bring up a very interesting point, and thank you for I guess you referenced me. What we do here, doing the personal injury litigation. I don't know that I would agree that I'm never going to see my adversaries again. I've seen a lot of the same adversaries for a long time, but whenever you see them, and they're often and basically almost always attorneys that work for insurance carriers. So you'll always see them in a different capacity on behalf of a different brand new client with a completely different accident.
Exactly.
But we have ongoing, often, relationships. Sometimes we get a brand new attorney, but it is a very different thing, I imagine, when it's not always litigation. Here, this is what we do. We take cases and we aggressively litigate to get the absolute best possible result we can for every individual client with their unique accident. And while I may see that attorney again, and we always want to strike that balance of being professional while fighting extremely hard and getting great results for our client, we're never going to have that exact same situation. And my client isn't going to need to do ongoing business with an attorney for Nationwide or any insurance company you might add. So I imagine that is interesting. You have to probably strike a very interesting balance when you're not only litigating against the same faces, but doing transactional work over the years with them.
Yes, exactly. Yeah, you summarized it quite well. You may be dealing with an attorney or management on multiple issues, and on one you have to be very aggressive. On the other, depending on what leverage you have or what the nature of your claim or the controversy, and others, you can't be that way. So it changes. It's very dynamic. And I think that the reason for that is it helps to maintain, a good relationship between the parties, which is so important so that the workers, can thrive, because it's not good for anyone if there isn't, good labor relations between union and management. Whether that's, on the union level or with the funds, like, you want to make sure that the employers, may be great with the union. Yeah, everyone's getting paid. No one has any grievances. No accidents. Everyone, is getting the overtime that they should or whatever. But like, for example, if the employer is not paying the funds, the contributions, excuse me, it owes to benefit funds, that's a problem for the union. So they got to, resolve that, and the funds will do that. Um, and it's all, kind of interconnected. It's an ecosystem. Um, and our firm it has its finger on each part of that.
And when issues do arise, how are they often resolved? Do you have cases that you're taking to trials in front of juries, or are you arbitrating? How does it work in this field?
Very rarely am I in court. Very rarely. You are probably in court way, way, way more than I am. I'm sure you have me beat very badly.
It's not a competition, but thank you. That is true.
So for us, matters are resolved in arbitration. And
by the way, I assume a lot of our listeners, those who maybe are find us on our websites or LinkedIn, a lot of people probably know what is arbitration. But for those who don't, what is it?
Arbitration is private dispute resolution, where you're in a conference room, not a courtroom, and there's an arbitrator that's a judge and jury deciding your case. For our cases, it's a single arbitrator, and the arbitrator is neutral, and he or she is there to decide whether the union's grievance has merit and what the relief is. And it's 99% of the time it's the union that has a grievance. It's really never ever the employer that does. And it's a formal process. Each side is represented by an attorney. There's witnesses, there's opening statements, there's closing statements, there's cross-examination of witnesses. Evidence is introduced. The rules are a little relaxed as far as hearsay goes, and sometimes relevance of evidence. But it's a real, important process for the orderly resolution of disputes between union and employer. And it's very important that arbitration is, and when I deal with it, because that's the quid pro quo. That's the deal for not striking. That's how you resolve the dispute, is arbitration, not with the economic weapons of a strike or a lockout. Strike being when the union walks out, takes the workers out, and they don't work. Lockout being where the employer says, I'm not going to let the workers work, and I'm going to, cause them some economic harm by not paying them and locking them out. So the deal is, okay, well, we'll arbitrate it. We'll get a final and binding resolution from an arbitrator. And there's usually no appeal. There are grounds to overturn, or the legal term is vacate, an arbitration award, but it's a very high bar. And I've never seen a contract that allows for its own internal appeal mechanism. It's final. And that's a lot of what we do. And we represent the workers in those hearings. We represent the union, of course. And each side has to live with the decision, good or bad.
And curiously, are these arbitrations still done mostly in person, or are they virtual, or how's that working in this new, much more virtual world we're living in?
A lot of it is remote. What we have been doing is, like, I guess, a hybrid approach where each side may be with its own, like on a single screen. So like me, the union representative, the grievant would be in one room, the arbitrator would be on his or her own screen, and then the employer would either be separated on its own screens, plural, or in a single room, and they'd be, all together. I haven't done an in-person hearing. The last in-person hearing I did was last January, and the employer insisted on that because of the amount of documentation in the case, even though, I mean, it really wasn't that much, but he really wanted it to be done in person. And so it was. Sometimes it's better to be in person when it's a termination case, meaning someone's been fired, and so the arbitrator is ruling on whether that person, whether the employer was right in firing that person, because this is, in a sense, life and death. Either I'm going to be put back to work or I'm going to be unemployed and I have to find a new job, which can be a very scary thing. And the worker may feel more comfortable just seeing all the faces in person. And, you could see where people's hands are, what they're looking at, where, when you're on Zoom, it's a little bit harder. And there's a little bit more of a trust issue. And, for me, that's kind of easy. Like, I'm used to it, but for workers aren't. I mean, we do this all the time, but the worker, this may be the first time ever. And so, transparency is very, very important. So that's what I found. And let me just say one more thing about arbitration. Unlike litigation, there's really no discovery. Discovery being like exchange of facts before the hearing, so you kind of know what each side is going to say, so that you avoid these quote unquote Perry Mason moments. Sometimes there are Perry Mason moments in an arbitration because you don't have that. There's no depositions. There's no real document requests or interrogatories. I've heard it described as rough justice. It's justice, but it's not. It doesn't have all the trimmings of a real court litigation. But that's how arbitration is. At least in the labor field, sometimes you get more for private employment disputes. But for what we do, no.
How do you prepare a client for cross-examination at an arbitration when you may be confronted with documents or issues you didn't know about?
Look, it can be hard. It's flying at the seat of your pants. And you are, doing the kind of not the prep, but the analysis in real time. Like, okay, is this relevant? Is this, off base? Is this good for us, bad for us? And usually the clients will know already, like, what they're going to be asked about, especially if it's like, a fact dispute, like, where were you on X date? What were you doing? Or where were you in the plant? Who are you talking to? Whatever. Sometimes, though, there are curveballs. I had a case once where it was a discipline case, and the employer attempted to introduce some blog posts. And I forget the why they were attempted to be introduced, but I objected strenuously. I'm like, this is totally irrelevant. What does this have to do with whether this person engaged in the misconduct that the employer said he or she engaged in? And the arbitrator fortunately ruled in our favor and disallowed that evidence, and which was a big win, because arbitrators usually will say, well, I'll let it in, but give it the weight it deserves, or the weight that I deemed it to be given. But here it was just a flat out no. So that was good. So it can be difficult. In other words, it's really hard to do that prep. Sometimes it's really just like not possible, and we just got to go in and do the case and put on a better case than the employer.
I think you also earlier mentioned your firm does some work with collective bargaining, right?
That's correct.
Do you actually work in drafting the collective bargaining agreements?
Yes, we do. So that's a big part of what we do is contract negotiations. And what we do is we're, sitting across, so to say, from the employer. And by the way, those are also now a lot or done on Zoom a lot of times, instead of being, all together. But, you're sitting across the table and you're listening to the proposals and you're drafting the language that shows the intent of the parties. What do we mean when we say this at the table? What does that really look like? Now, that's really important, to get the language right, because, I may not be here someday, right? But that language may live on, and neither will my counterpart. And so we got to make sure it's right to live on, after we're gone. And that reflects what the parties intended, because if it doesn't reflect what the parties intend, then you have problems. Then you have disputes, you have arbitrations, you have disagreements, and that we try to avoid at all costs. So that's what I'm there for, and also to advise on, the legality of things, whether it's under state law, like state, sick leave, which is prevalent here in New York, COVID sick leave, hours of work, overtime, workers' compensation, sometimes FMLA leaves, and the subjects of bargaining under the National Labor Relations Act. What's mandatory subject of bargaining? What's permissive? When can the union say no to something? When can the employer say no to something? And advising on strikes and other concerted activity, like handbilling, putting up a banner. It runs the gamut, from the actual hard lawyer work of, contract drafting to advising on concerted activity that the union may want to do in support of its demands.
And Chris, what are some of the issues you're seeing these days with labor organization or collective bargaining, or some of the things you mentioned? If you were had the opportunity to meet a union executive that you haven't met, what would you be saying? What are some of the issues they need to know about?
Right. So that's an important question. I think the first thing I would say is a lot of the organizing seems to be going on at the ground level. You have the workers kind of organizing themselves, where a national union is not coming in to organize. You have, for example, Amazon Labor Union. That's a union where the workers organize themselves, basically. You have that at Trader Joe's. I think at a store in Massachusetts and in the Midwest, it might be Minneapolis. Starbucks. Those workers each organize, the respective stores, and I think they're affiliated with SEIU, but still, that's ground level, that's grassroots. Same thing with Kickstarter, the first tech union, or the first union at a big tech company. Those workers again organize themselves with, it seemed to me, somewhat minimal input from OPEIU, which stands for the Office of Professional Employees International Union. And they've had remarkable success. A few years ago, telling me Trader Joe's would unionize Starbucks, I find that hard to believe. But Starbucks caught on like wildfire. Amazon, they organized successfully the Staten Island warehouse. Kickstarter, they successfully organized that and reached a contract in June of 2022. So it's really been tremendous. And so for those union leaders, I would say, try and in some way leverage that, where you're giving maybe more latitude to those workers and letting them run with it, but still, being involved in providing the support of the national or international with union representatives and legal support, because, the independent unions, they don't have any dues money coming in. They don't have money to pay professionals to help. So it is important, I think, still to affiliate and have that that source of knowledge and other benefits that come with being, part of a larger organization, a larger structure. So that's one thing. And I would say the other thing would be to keep pushing on, and this, isn't something that I'm so involved with, but just generally keep pushing at the state and federal level, and also city, with legislation that protects and helps workers. We have the COVID sick leave in New York State. We have legislation in New York State that now allows farm workers to unionize. And that's a big deal because farm workers are not allowed to unionize under federal law. It's only a state law issue. So we have New York, California, and I think Washington State that allow that. So that's really great. And that's, something unions push for. And, higher minimum wages, better, workplace protections to raise the floor so that when unions demand those sort of things, wages, better benefits, the floor is already, lifted that high so that those demands aren't I guess seen as overreaching, that they're seen as reasonable. So those are the big things, and of course, protection of pension benefits, and other benefits that the workers get. Make sure that those contributions are coming in, and you get more contributing employers into those funds to keep those funds solvent.
I'm not sure if I asked you this at the beginning, Chris. We talked a lot about all the things that unions should be aware of, like if they're going to form and start making all these decisions. But lots of employees in this country aren't involved in any of union. What exactly is the benefit of union? Why would you be telling employees or executives to be doing these things and to be working with lawyers to create a good union and to have a good collective bargaining agreement? Why is it necessary?
A union protects the workers, whether you are a cashier at Walmart or an attorney for some private company, everything in between, all sorts of job titles and classifications and types of work, different industries. The union is there to help you, and to preserve the wages, hours, working conditions that you have, and to also make them better. Without a union, without a contract, anything can be just taken away, as long as it's not illegal to do. And because most of us are at-will employees, the employer can do anything it wants except for an illegal or discriminatory reason. Taking benefits away, reducing your wages, firing you, suspending you. It's all the discretion of management, their sole discretion. The only way to have a check on that power, besides just laws and regulations, is to have a union with a union contract that puts in writing what management can and cannot do. And it's a tremendous force because of the reaction you get from companies when they hear the word union. It's a 4-letter word. They call in the cavalry to stop it at all costs, and that alone shows this must be good for the workers if they don't want it that bad. With captive audience meetings, one-on-one meetings, them constantly saying how a union can't help. They can't promise you anything. Why would you pay dues? Why would the company care what you do with your money? When would a company ever care what you do with your money except when a union is involved, right? So it's a tremendously good force in the world, and has lifted many people into the middle class and beyond, and raised their station in life and gave them protections that they otherwise wouldn't have. So that's the upshot.
So I was very excited to have you on the show, Chris, because so much about what you do is a different aspect of kind of the work we do over here at Hill and Moin in fighting for the rights of injured workers. A lot of what you're doing is trying to make sure that people can work and have a good, healthy, safe, fair, equitable working arrangement over the course of the career. And it sounds like there's a lot of litigation, but also a lot of transaction negotiation to constantly making sure they have someone like you and your firm fighting hard for their rights so they can go to work. And I feel very passionate and happy that people like you exist. And it's my job to step in when they do get injured and can't go to work anymore, to make sure their rights are protected, and that if they hopefully they eventually can go back to work, and if they have people like you that have a good job waiting for them with good benefits, and if they can't, hopefully they're getting fair and reasonable compensation for the rest of their life if they can't.
Exactly.
Return to the good union that you helped negotiate for them.
Exactly. Very well put. Yes. 100%. Right. So you pick up where we leave off, in a way. We're here to represent the collective interests of all of the workers, plural, and attorneys like you are there to vindicate their individual rights. And it's very important, very important.
Chris, if any of our listeners wanted to get a hold of you or your law firm, how would they do so?
Yes, you could call us at 212-868-6300. That's one way. And you can also email me at C, like Charlie Baluzy, my last name be like boy, Aluzy, Y like Yankee, at carykane.com, CaryKane.com.
Chris Baluzy, thanks so much for joining us here today. It was really a great pleasure getting to speak with you and hear about all the great work that you do to protect the rights of workers when they're not injured. Know that they'd be fighting for the rights hopefully they get to have, but if they don't, then we're here to pick up the slack when they aren't entitled to those benefits at all. And
right,
we really appreciate the work you do on behalf of workers out there. For those of you watching, if you want to get in touch with me, my name is David Swearin. I'm the senior trial attorney at Hill & Moin. Our focus is on construction accidents or premises liability cases where workers such as the ones that Chris might represent happen to have one of those serious injuries that someone may be at fault for, whether it's a violation of law or someone's negligence. If you have any questions that you're entitled to significant compensation, whether you're in a union or not, you can reach us at 212-668-6000 or at hillmoin.com. Until then, or until the next episode, my name is David Swearin of Hill & Moin, and it's my pleasure to speak with you about these pressing legal issues and great guests like Chris Baluzy. And I look forward to the next episode. We'll have another great guest with us on another episode of Rising Leaders of New York. Thank you.
Thank you so much, Dave.
You've been listening to Rising Leaders of New York, hosted by David Swearin of Hill & Moin, LLP. You can catch prior episodes at www.hillmoin.com and on YouTube, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive reviews, comments, and sharing this show with others.